So our next panel is entitled Reforming Criminal Record History Information Policy. I will introduce the moderator, Brian Murray, who again is one of our Quattrone research fellows. Brian has been with us for 2 years. He came to us from a distinguished career in public defense and with community legal services. He's had a long-standing interest in the role that criminal records have in the ability of people who have come through the criminal justice system to rejoin society and you know, once you've paid your debt, how do you get back on your feet? And so he's assembled a terrific panel, and I think we'll have every bit as stimulating a conversation as we had before. Same format, so the index cards, and we'll have people coming around to collect them to present your questions, so write early and often. Thanks.
John, thank you for that introduction. As John mentioned, our panel is titled Reforming Criminal Record History Information Policy, which is an area that I encountered a lot in practice and continue to research here at Penn and plan to do so in the future. The short way of kind of understanding this panel is that it's going to address kind of the stigma that results from having a criminal record or from the existence of criminal record history information. I'd like to kind of set the backdrop for the conversation before introducing our distinguished panel here. You would really be hard-pressed to find someone, or to, if you think through all the people you know, to realize that there probably is somebody who has been touched by having a criminal record, and that criminal record has affected their life in countless number of ways. We know family members, coworkers, friends, other individuals who have encountered the system who can't seem to kind of get out of it. And that's regardless of whether they're charged with a felony, misdemeanor, or low-level charge, summary citation here in Pennsylvania, or kind of a below-the-level misdemeanor record in another jurisdiction. You know, this phenomenon has become more and more exposed in the past probably 10 to 15 years. There was news a couple of days ago about Target, one of our favorite chain corporations, settling out a case involving asking applicants for positions about their criminal record history information. As one of our panelists, Janet Ginzberg, can attest, there are stories of countless ex-offenders who struggle to re-enter, and this then becomes also a punishment theory issue as well. Criminal record history information is possessed by local, state, and federal agencies across the country, spanning all different branches of government. The FBI and local police all have, and all levels of courts maintain this information. And just to give you a kind of an idea of the scope of the problem, if you conceive of it as a problem, in 2012, state criminal record repositories had rap sheets on approximately 1/3 of the American population, which also simultaneously exist in the FBI database for criminal record history information. It's estimated that the FBI adds approximately 10,000 names to its database each day, and in total has record information for 250 million arrests. And over the past decade, the FBI has processed nearly 17 million requests for background checks for non-criminal purposes. So outside the boundaries of law enforcement, these are the checks that landlords, employers, other decision makers run in order to make decisions about people who have cycled through the system. Now, criminal record sharing is also a fairly profitable industry. The private background checking industry maintains an annual revenue of approximately $4 billion, but unfortunately those profits don't always come from good work. Many of the records disseminated by private companies contain inaccuracies or remain even after a remedy like expungement has been pursued. And laws like the Fair Credit Reporting Act, which is a federal law, as well as state analogues, don't do very much to protect individuals that have had their records erased. The number of agencies creating and storing this information only seems to be increasing. If you're fairly tech savvy, you might be able to set up a background check company with a laptop in your garage and then sell criminal records for profit. Policymaking in this area thus implicates a variety of actors: legislators, executive agencies, the police, court administrators, prosecutors, judges, employers, landlords, other private actors who might use this information on a daily basis. So today we've assembled a panel of individuals, a prosecutor, a legal aid attorney, and a professor who have spent a great amount of their careers in this precise field. And we're going to have a conversation about the range of topics that come from having a criminal record and that relate to criminal record history information policy. And those topics include purposes of punishment, privacy interests, the effect of technology on the administration of criminal justice, the relevance of the First Amendment, if any, and reentry policy. We'll talk about how criminal records exist and are shared, what the rationales are behind those existing policies, whether remedies like expungement, pardons, and certificates of relief are useful, what the responsibilities of prosecutors, defense attorneys, legal aid attorneys, and other players in the system are, and whether interventions like ban the box or other remedies are useful and worth continuing. So let me, without further ado, introduce our panelists here. First, we have Professor James Jacobs, who is the Chief Justice Warren E. Burger Professor of Law at the New York University School of Law. He teaches and writes in the criminal justice area, focusing on criminal procedure, federal criminal law, juvenile justice, criminal records issues, and forfeiture. He's published 16 books and more than 100 articles. His most recent book, The Eternal Criminal Record, is a leading treatise on how criminal records are stored, shared, sealed, and erased. It makes transparent what has now become a routine feature of American life, the tracking of criminal record history information. It also situates the availability of such information against other values underlying our legal system, such as the right to privacy and the restoration of rights. Janet Ginzberg, to my right, is a senior staff attorney in the Employment Law Unit of Community Legal Services. She's a former colleague of mine. She advises and represents individuals in a broad variety of employment-related matters, including those related to discrimination on the basis of criminal record information. She has extensive litigation experience related to criminal records issues and has advocated for legislative and policy reform in this area. And she currently serves on the legal committee of the American Civil Liberties Union of Pennsylvania. Mike Lee is an assistant district attorney in Philadelphia, serving as the director of legislation and government affairs. In this role, he promotes legislation supporting criminal justice reform on the county, state, and federal level. A graduate of Drexel Law, he co-founded the Philadelphia Lawyers for Social Equity, a legal aid nonprofit dedicated to addressing the collateral consequences of an arrest record. So I'm going to begin with you, Professor Jacobs, to hopefully set the table a little bit more. In your book, The Eternal Criminal Record, you devote several chapters to explaining the architecture of the criminal record system that exists. To the extent that you can, and obviously it's difficult to synthesize an entire book in a couple of minutes, but how did we get to where we currently are with the storage of criminal record history information? What's the history? What's the story that you tell in your book?
Well, a lot of this is driven by technology, and it's not surprising that people seek information. We're all information seekers, and after the information revolution, this becomes so much easier for better or for worse, as we're seeing in the current congressional investigations of Facebook. So we start with the police records. In the 19th century, we didn't have any national system of police records. Every department kept its own records. There was no coordination. And slowly in the 20th century, with the rise of the FBI started inviting police departments to send in their criminal records and to build a national database. And that took a long time, and it didn't just happen. the way that I got into this topic was working on gun control issues and the Brady law. And some of you may know the Brady law, passed in 1993, required the Attorney General to have a functioning online criminal record database so that vendors could check in real time whether a prospective purchaser had a disqualifying criminal record. And they poured billions of dollars into improving the reporting of criminal records and to the storing of criminal records and so forth, to the point where that system was up and running in 1998, and where we now have a remarkable system of police records such that any police officer anywhere in the country who stops somebody can find out in real time whether that person is a fugitive, whether the person is wanted somewhere, whether they have a criminal record anywhere in the country at anywhere in their lives. And so this has a lot of advantages for policing. It also allows the police to connect the dots when they're doing investigations, and they never erase this information, or rarely. Even when they're ordered to, they rarely do. And their explanation would be, who knows when a crime will occur, and we will get some evidence and it will enable us to connect the dots. Okay, so that is an amazingly large system. It is basically a system for the police and the criminal justice system, but legislation has made it available to some non-law enforcement agencies and private agencies as well. Then there's the courts. So our courts have always had a tradition of openness. Our courts are, and the Supreme Court has held, the courts have to be open to the people. That doesn't necessarily mean that court records have to be open to the people, but that has always been our tradition, that anybody could walk into a courthouse, could look at the current or past calendar of cases, could look up a name and find out whether there was a criminal case adjudicated in that court against a particular person and what happened. I would say, although there's never been a holding that that is an absolute constitutional right, it is close to being understood as a constitutional right. So that information was always available, and people could go to courts and get it. They could hire private investigators who could go around and look for it. But the information wasn't so easy to get for a non-specialist. Wouldn't know how to do it. It's time-consuming. And when the courts digitized their records, they started to make them available first by computers at the court and terminals at the courthouse, and then from remote locations. That information just became exponentially easier to retrieve. And then two, when the court systems in the states moved to a unified administration, or what we call unified court systems, you had a state court agency that had put together databases of all of the cases from that entire state. And then they went back and they started to scan in previous records. So this made it infinitely easier if that court administration database was available to any inquirer, just like the person who used to go to the courthouse. Now you go to the state agency and you ask about James Jacobs and you have a birthday or something, and they would give you, in most states, my criminal record history, if there was one, and in some states began selling the whole database to customers. So if you wanted the whole database, you could just subscribe and you could download it into your system. That brings me to the third pillar of the building of criminal records, are the private vendors. So now we have private vendors who do subscribe to these statewide databases. They download the whole database into their computers, and so they become a third repository of criminal records, and they use them for their own clients, and they also are available to other small criminal record vendors who, for a fee, are able to search their records. Most employers and even many government agencies obtain criminal background records from these private vendors. They just find it easier, more efficient to work with the private vendors than to work with government agencies. So in a few words, that is the architecture of the system. There are some other nuances we can get into, but three basic systems of criminal records: the police system, the court system, which I should have said is not nationalized. There's no national database of court records. It is organized at a state-by-state level, and then the private vendors.
Thank you. Janet or Mike, does that kind of architecture fit with your experience practicing with respect to criminal records in the state of Pennsylvania and more locally here in the city?
Who do you want first?
Mike, why don't you go first?
Sure, and thank you for having me. And I would say, yes, that does very much mirror my experiences. And also to build upon that, I think as a society, we're transitioning from the information age, which is how fast can you give me some data, right? Like, I think most people here remember you used to measure download speed by how long it takes to download Encyclopedia Britannica. Is it 2 weeks, 1 week, couple days? Now, if it's not readily available, something's wrong. So we have the ability to get information in real time, but now we're starting to say, wait, that's not enough. We need to be able to interpret and analyze this data and not just receive it. And I think that that is the role that these private vendors are trying to fill, is say, we will not just give you raw data, but we will do a risk assessment or some other kind of analysis to this information with very little understanding of the intricacies of how each state might function its criminal justice system, or even more specifically, how jurisdictions within a state may do that. So I do very much agree with the timeline and process as it's laid out, specifically the distinctions between something like a law enforcement record, which is a record of arrest, versus a court record, which is what the court did during the life of the case, which is different than what a private vendor would disclose, which is probably a culmination of publicly available information plus some type of analysis that they're trying to sell, usually as a risk assessment or alert system.
And I would add to that I completely agree that the growth of technology has contributed to this enormous compilation of criminal records and court records. One of the things that I think can't be stressed enough, though, is that when you have that much information coming in that quickly, the number of inaccuracies in those records are enormous. We see in our practice, am I echoing a lot? Can you hear me okay? Okay. One of the things we see in our practice is that the availability of records that has occurred through this technology not only leads to the information being used when it's, even when it's not allowed to be used because it's there and it's accessible, but the inaccuracies are incredible. You know, information is only as good as the people who are giving it and inputting it and spelling names correctly. So what we see in our practice as a result of this huge mass of criminal records that have been collected is people having background checks done and getting records back on them where it's not really them because there may be other James Jacobs with the same birth date. The information is incomplete. The information is just wrong altogether. The information hasn't translated from the disposition in the court to the FBI record. We heard a statistic some years ago. The Pennsylvania State Police, which is Pennsylvania's official repository, bragged that their records were 70% correct. That's troubling. You know, if the record keepers, the official record keepers' records aren't correct and up to date, then all of the records that people are getting about people and that are being sent to the FBI is also not correct. So as technology grows and gets easier, I think we all ought to be working on and being concerned about the accuracy of the records and the extent to which that ease of access to them hurts people as well.
Professor
Just a quick addition to that. The biggest problem with accuracy comes with the police record system for a number of reasons. It really isn't that important to the police because if there are mistakes in that record system, they can rectify it in a fairly short order by calling the DA's office or just listening to the defense lawyer or something like that. There's especially been a problem with putting dispositions into the criminal record system, and the courts don't always put it into the police and FBI record system. But the police find out somebody's been arrested, they can then check and they can follow up on it. Obviously, the DAs can also. But if that database is used by private employers, they can't easily check up on it. So the police record system was not made to be used by private entities and private employers. It works much better and works pretty well within the criminal justice system itself. But outside that system, if I call up and I say, you know, I see the person was arrested, what happened to the case? We get this at the law school sometimes. We used to look up, people would divulge a criminal record, they were arrested. How would we follow up on it? Call the police department somewhere that we're trying to find it? Nobody would take that call. Nobody has time to follow up on it. So it's a real problem. The court records are much more accurate.
We see a lot of inaccuracies, often. So, you know, one of the things we do is work on trying to fix them, but there's certainly still a lot of work to be done.
I mean, the court records ought to be pretty accurate to what happens to somebody in court.
We often look at both the state police record and the court record and try to figure out, you know, sometimes there are charges not appearing on one or the other.
I think it's also important to know that technology has impacted the practice of law as well. So I think each year our record keeping improves as a profession. So records from the 1990s that are trying to transcribe what someone hand wrote into some type of digital format, there's bound to be errors in just how you read what this charge was, or trying to find a relevant comparative charge that exists today because it's not in your code. If you're trying to transition over from assault and battery, well, was this a simple assault or aggravated assault for coding purposes? And disposition sheets and things like that, I think, aren't used enough to make sure that it's a quality check for the court records or the police records or the private employer records. But I think most importantly, resolving the discrepancy is generally placed upon the person who the information is about. And that is one of the big problems. And from a prosecutorial standpoint and seeking justice, that's not what we're all about. where we don't want to put the burden on someone who's been just accused of a crime to dispel the stigmas and misinformation that's being reported about the outcome of a case.
So we'll certainly get more into that in a couple minutes. I do want to ask one follow-up question for all three of you, which is on this topic of inaccuracies. So moving forward with Professor Jacobs' kind of framework, police agencies have records, courts have records, private actors have records, and whatever other governmental agencies might have records as well. Why is it so difficult for those agencies to coordinate with one another? And why is there sometimes competition amongst them to organize with one another? I mean, I remember when I was in practice, I would get a response from the state police when trying to correct with a court record that was essentially, would say something to the effect of, well, that's how the courts do it. This is how the state police does it. We know that guy was actually guilty. It's like, well, here's the court record that shows he was actually not guilty. And there wasn't really a desire for collaboration there. Could you speak to why there isn't a stronger spirit of trying to, at least if we're going to make this public, project it accurately?
Well, I think the agencies have different roles and they have different goals. So, the police want to maintain a database on offenders and people they think are offenders. So even if a case is dropped, maybe there was a suppression motion or some other reason, the case doesn't end up in a conviction. From the police standpoint, this is a record of an offender. They keep on it, and it may end up being relevant in the future. The courts have a different function. I think in the courts, I want to keep an accurate record of what transpired in the court systems itself. And, so you ought to be able to look in the court file and find out what motions were made and what orders were given in the courts. So I think they have just different purposes. And I said that in the beginning. The police record system was created for policing. It wasn't created as a background checking system for employment purposes.
I would agree with that they do have different roles and purposes. I also think that just the sheer number of records and the size of the bureaucracies we're dealing with contributes to the inability to come up with any form of a unified system or way of correcting things easily.
Professor Jacobs, does the U.S. approach in terms of making the default rule of kind of making this information publicly available, how does that compare to other jurisdictions? And I mean, you've written some articles about continental European countries and how our experience is different. Could you just speak to that?
Yeah, well, I collaborated on a couple of articles over the years with my colleague from Barcelona, and I remember her trying to explain to me how they handle the publicness of their criminal records. I didn't think she really understood her own system, but I came to realize that she did understand it. It was so much different for us from ours. So their court records are not available. Definitely their police records are not available. But when she said the court records aren't available, I said, how can that be? Don't you have open courts? And she said, of course we have open courts. Anybody can come to court. But the judgment and the verdict is not public. I said, what? What? So you can watch the proceedings. And of course, in continental Europe, they don't have trials the way we have trials, where it's all condensed into a fairly short period of days. Their trials drag out. A lot of it's on the papers. So you can go to court and hear parts of it. But when they render a judgment in Spain, that judgment is confidential. So you don't know what happened. Okay, so I said, well, what happens when they publish the court decisions? She said, well, before they publish them, they go to the Department of Anonymization. And that really shocked me. I've been teaching criminal law for decades, and no one ever told me about the Department of Anonymization. Right? No one tells me anything. Oh, yeah, the court sends the information to the Department of Anonymization. They anonymize all the names and any identifying information. And so when it is published, some report of the decision, you couldn't link it to any person. Well, then how could you look up a case? In Europe, you can't look up a case by somebody's name. The cases are organized only by topic, like auto theft or embezzlement, and then you can read about cases that were resolved under those crime categories, but their whole system is different. They treat a person's criminal history as part of their private, personal identity. And again, I was really shocked by this, which is so valuable for doing comparative insights from comparative work. I said, that's private, whether you've been convicted of a crime? And she said, of course it's private. It reflects negatively on your character. I said, well, the whole criminal justice process, the People versus Jones, reflects negatively on your character. I thought, that's the point. The People accused Jones in open court of a crime. How could that be confidential? And she's, in Europe, under their data privacy rules, that's considered a matter of private information. It's a matter of personal dignity. And so you can't publicize it. You can't write about it. You can't post information about it on databases. And just to polish this point off, there was one case she showed me where people had put up a list of names of people who had been convicted of torture during the old regime in Spain, or still had pending charges of torture, and that was placed on a database, and the subjects of that information challenged it in court, and the Supreme Court of Spain ordered it to be taken down. I think they even imposed a fine on the people who posted the information. That information of who has been convicted of torturing the citizenry is confidential information. Now that is a difference from the U.S. position.
And Brian, I think another big difference, and it's somewhat related to how in the U.S. we very much associate criminal activity or conduct with bad people, and not just reflect negatively on someone's character, but it's who you are. And I think that narrative comes from how our elected officials, particularly in law enforcement, have gotten elected, which is using incarceration rates, using inflammatory cases or fact patterns as a way to say, I'm protecting a certain population, right? And the fact that we have for generations elected prosecutors or sheriffs or even governors based off of how often they pursued a death penalty, how often they would grant a pardon or something like that, is a direct correlation to the public desire to know not a criminal record, but who is a bad person. And this is the easiest way to deem someone a bad person, is if they have a criminal conviction. So when we look to other types of risk assessment for public safety, like gun control, the easiest thing to do first is deny people with a record, because they're inherently bad people, their constitutional right to a firearm. Or deny someone with a criminal conviction an opportunity to work with a vulnerable population, and so on and so forth. So I very much think that the public nature of this is closely tied to election politics and things like that.
I would say, other than I think I'll go practice in Barcelona, because it sounds pretty nice. I would say that even though we're worlds apart from the European practice that Professor Jacobs has described, there is at least here a growing recognition that records shouldn't be held against people forever. I do agree with Mike that we do have a attitude in this country, legislators certainly do, and a lot of employers do, once a crook, always a crook. And I think that perspective is not only not borne out by the social science research, but also there is a growing movement. Reentry is a big deal right now in our country. There are, more and more academics and legislators are looking at recidivism rates and people's rights to put their past behind them. And I do think that there is slow movement towards, both in the courts and the legislatures, in recognizing that people shouldn't forever be the crime that they once committed.
So I think that's a nice transition then into the next part of the panel, and I'll start with you, Janet. Having been in the position you've been in for several years now, what are the main challenges that you see clients come in to your door with relating to public criminal record history information? And then, what are the remedies here in Pennsylvania to the extent that they exist, and how useful are they?
I've been at CLS for August will be 19 years, and one of the statistics I always like to tell is that when I started at CLS, the employment unit got maybe 450, 460 cases a year. We now get over 1,500 a year, and that increase is almost completely, it's almost exclusively people with criminal records. It's an enormous problem for people who have records. In our experience, there is no record too old or too minor to be affecting someone's ability to get a job. It may not even be a conviction. Since the arrest records became public around 2007, people come into our offices by the hundreds where they've got arrest records, so records that didn't end in conviction, that's affecting their ability to get a job. Even though employers are not allowed to consider arrests, they do. So some of the remedies we see, I'll tell you a little bit, very briefly, what CLS's employment unit's practice is. Aside from just regular employment law, anything affecting people's employment, what we do for people with criminal records is multifaceted. We will help people to the extent we can clean up their records. There are laws in Pennsylvania that allow people to expunge arrest records, to expunge certain kinds of diversionary records. So we help clean up records. We help with pardons where we can. Where we can't help clean up records, there are laws, both federal laws and Pennsylvania laws, that do protect the rights of people with criminal records to be considered for employment. Title VII, for example, the federal discrimination law, there's a policy guidance that tells employers that they can't just have blanket bans on people with criminal records. They have to consider certain factors, such as the age of the conviction, the nature of the conviction, the relationship of the particular charge to the job, what the person has done since the conviction, so rehabilitation. There are several state laws that protect people's rights as well. There is the Pennsylvania Human Relations Act, which, similar to Title VII, restricts to some extent how employers are allowed to consider criminal records. There's also the Criminal History Record Information Act, CRIA. Section 9125 of CRIA says that employers can consider an applicant's misdemeanor or felony conviction only to the extent it goes to suitability for employment. We do use these. You asked me about the effectiveness of these laws. We do use them. We do file charges. We do file lawsuits under 9125. And we do use them to help advocate on individuals' behalves to approach employers who we believe have illegally restricted, fired or not hired someone, and if we can't, through demand letter and advocacy, say to them, hey, you're not allowed to consider this record. It's too old, it's too minor, it's not related to the job enough. Sometimes we're successful in advocating on their behalf. Sometimes we have to bring litigation or file charges with the EEOC or the Pennsylvania Human Relations Commission. So those are the main remedies that we have in Pennsylvania, and we also do some bigger picture policy work, legislating with the legislature, advocating with the legislature, advocating with administrative agencies to try to get them either to change the way they implement their own policies regarding criminal records, or trying to change what some of the laws around criminal records and restricting criminal laws are.
And just a quick follow-up for you, Janet. In the course of litigation, have you found that courts are receptive to some of the arguments that you're making under these statutes, or are they inclined to interpret them fairly narrowly?
Well, there's not been a lot of litigation about 9125, and what there is has been interpreted narrowly. The Pennsylvania Commonwealth Court has been fairly open to arguments regarding the rights of people with criminal records. We were involved in a case, there's a law in Pennsylvania called the Older Adult Protective Services Act, UPSA for short, which restricted, it regulates in general nursing homes, home health agencies, that sorts of long-term care facilities. It also had a criminal records provision in it, which in 1997 was amended to prohibit covered facilities from hiring people with a long list of criminal records at any time in their lives. It was a lifetime ban. I was in fact hired at CLS to help challenge that law 19 years ago. And I've unfortunately been working on that issue for 19 years. We brought a lawsuit to challenge the constitutionality of the statute back in 2001, after several years of sort of getting the strategy together, getting the litigation together. And we got a decision in our favor. It was a pretty limited decision, but we thought that the legislature would have to go back and change the law and make it more rational, not have these lifetime bans, not allow the employers to look at everything forever. I then spent the next 10 years working with the legislature trying to make the law more rational, and they didn't do it. So we ended up bringing another lawsuit called Peek versus Commonwealth. In 2014, I think we brought it. And in December of 2015, the Commonwealth Court issued a much broader ruling saying that the Commonwealth cannot put in place these lifetime bans for people with criminal records. That people with criminal records under the Pennsylvania Constitution have a right to put their past behind them and not to be stigmatized forever. And they also made a very broad ruling that the state, the Commonwealth, is not allowed to put in place what they call irrebuttable presumptions, meaning they're not allowed to presume that once a crook, always a crook forever, without individuals having an opportunity to rebut that presumption. I will say that the legislature is now trying to fix the legislation to make it much more rational. I suspect that will go on a long time. I hope not to have to bring a third lawsuit. I would like to retire one day and not be working on UPSA challenges for the rest of my career.
So Mike, before you entered your current position, you were involved in the Criminal Records Expungement project here in Philadelphia.
That is correct.
And I was hoping you could speak a little bit about kind of the rationale behind that project, and then kind of its successes, and what was the demand like for the services offered by that project?
Well, when I graduated from law school in 2009, it was a little economic hiccup called the recession. And a lot of employers were not hiring. either if you had a criminal record or not, law degree or not, and I needed to find something to do in my career. I've had anecdotal conversations with friends and family. I had some conversations with colleagues that were at community legal service, like Mike Hollander here in the front row, some of my other colleagues from some legal organizations, and we pretty much decided, like, let's try to make a change. So I went to the courthouse while I was studying for the bar and just watched how expungements were being argued, how often were they argued, what was the impact. And unfortunately, as great a remedy as this was, it wasn't really being provided in the demand that the city was requiring. So I decided to take it upon myself to really spearhead this narrative that how we use criminal records is not right. And it's disproportionately impacting people that look like me, people that grew up in Philadelphia, and we really, as a profession, need to help people understand that the use of criminal records outside the criminal justice system needs to be reevaluated and kind of hit a reset on it to keep pace with technology. One thing that I did was I reached out to several law schools, including University of Pennsylvania, to see if law students would be interested in getting some client interaction and courtroom experience. I was very surprised by just how big a demand there was for direct legal services in such a limited nature, and was a little concerned that it was too narrow to build a whole nonprofit around. But the use of criminal records, unfortunately, is such, you said, a $4 billion industry, and we were able to carve out a few $1,000s to have a nonprofit sustain itself just on this one mission of raising awareness and changing the narrative around criminal records. We trained law students, regardless of where they might practice and how their career might take them, to take a step back and meet people who have been arrested or convicted of crimes that live around your school. And you can interact with them on a bus and not know if someone has a criminal record or not. You can go to a supermarket or a movie and not know if someone has a criminal record or not, and most of the time you're safe. So why is it that all of our risk assessments, when people try to be productive, it's adversely impacted by the existence of a criminal record? So those were some of the main reasons why there was such an imperative to get started. We also wanted to give some backup to CLS. And at the time, it was really trying to help them reorient themselves on traditional employment issues so we could help take up the slack for this overlap of criminal law and civil consequences in that whole world. I'm happy to say that the clinic we started with University of Pennsylvania Law School is still alive and well. And I believe this year, although I was only there through the fall, they were still averaging about 150 to 180 impacted people every month coming to a clinic in West Philadelphia to sit down and not really talk about criminal records, but to share their story of how criminal record is impacting them or how people treat them when they know that there's a criminal record, and also to help show students that there's a gap in our justice system, and the best way to bridge that is with communication. And reentry is everyone's responsibility and not just the person trying to open up the door, right? There has to be someone on the other side saying, come on in, I saved you a seat. And we're really trying to create that conversation and share some of the responsibilities of addressing this issue that's impacting 1 in 3 people and making a city like Philadelphia spend a quarter of its budget on public safety, primarily police services. So we want to help shift the money back into education and other areas of our government so that everyone can live a productive, safe, and happy life.
So this question will be for all of you, and I think, again, Mike, you kind of nicely anticipated with your response my next question, which is, so Philadelphia has a ban the box ordinance, and ban the box kind of took a number of jurisdictions across the country kind of by storm, and a number of jurisdictions have enacted them. So this question is for all of you. What are your thoughts about ban the box? I mean, there's been some research done on the intervention over the past 5 or 6 years, and a couple of studies that say that ban the box is actually not really doing very much, and we've seen no statistically significant effect in terms of its ability to get individuals through the door and hired, whereas there are a couple of other studies that say the opposite. Is ban the box a remedy that can do the work here that we need to have happen? It's after the fact. It's not changing the availability of criminal record history information, but it's impacting the ability of people to use it. So some thoughts on that.
Our office has worked on ban the box initiatives and worked with people across the country and helped to form Philadelphia's ban the box ordinance. So I come at this from a couple of different ways. One is that ban the box itself can mean different things to different people and places. Ban the box itself started out as an idea that on job applications, that question, do you have a criminal record, should not be asked, that there should be a level playing field and that people shouldn't even be asked the question until they're further on in the process and have had an opportunity to show that they are otherwise qualified for the job. I agree with some of the folks who say that ban the box in itself alone may not be enough of a remedy because, then they'll just be denied the job once they are able to be asked the question. I will say that Philadelphia's ban the box, we don't even really call it that anymore. It's called for short, we call it Fair Hiring Ordinance, but it has a long, fancy name. But Philadelphia's ordinance goes further than just saying you can't ask the question in the initial contact. It then goes on to say that employers are not even allowed to ask about people's criminal records until they've been given a conditional offer of employment. And then employers in Philadelphia are not allowed to consider they're not allowed to consider arrests at all. And they're not allowed to consider any convictions that are older than 7 years, unless there's another law or regulation that requires them to, or mandates or authorizes them to. So I would say that in Philadelphia, when it's this broad a ban the box, it is useful. We have been able to get people to work who have come to us, and not only have they been asked the question before they're supposed to be asked the question, but they also then employers who are not aware of the ordinance, if they deny someone a job because of a conviction that's more recent than 7 years, we've been able to say, you're not allowed to even consider that conviction. So ban the box in itself with just not asking the question, it is, I think, questionable whether it alone really levels the playing field, but there are movements to go beyond that.
Professor Jacobs, you want to add any?
Well, I think ban the box is a great idea. It was a great initiative. I like it because it was also voluntary in the sense that the government itself, ban the box was basically a government movement to pass laws about government hiring and saying that we will lead the way and we will not ask people about their criminal records until after they have a provisional offer of employment. And I thought that was a great idea, and that if the government could demonstrate that there was no risk, or at least an acceptable risk, in following such procedures, that might be very persuasive to private employers. But maybe also this connects to the previous question. The government, in a lot of ways, signals that people with prior criminal histories are dangerous. Mike mentioned about guns. There's a tremendous movement in the country to expand background checking. So it's like we have a completely different conversation. Background checking for guns, of course, and 90% of the people are for it. And if you've ever been convicted of a felony or a crime, a misdemeanor of domestic violence, you may never possess a gun for the rest of your life. And if you do, you will be subject to a 10-year felony sentence under federal law and also to private sentences, state conviction. Why is that? Because people who've ever been convicted of any felony are so dangerous that they cannot be trusted with firearms. Well, if that is the position that we're taking on firearms and guns, then it's not such a big step for people to say, well, I hear you, and having heard that, I'm a little bit cautious about giving people second and third chances in other spheres. And the same point could be made about sentencing. When a person's been convicted of a crime, if they have a prior criminal conviction, their sentence vulnerability is massively increased. And why is that? Because they have now demonstrated that they were dangerous before and they are more dangerous now. Our whole immigration policy is, or not the whole of it, but it is centrally vested in sorting out people with a criminal record and people without a criminal record. And so if you have a criminal record, there's very little, but not none, but there seems to be a big consensus that you can be deported as opposed to those good people without a criminal record. So there are so many ways. All of the licensing systems that the government runs, and if you want to get a license for X, Y, or Z, you are disqualified, or at least presumptively disqualified for that license if you have a criminal record. When I was writing my book, I was struck by the licensing requirements to get into the legal profession. What's our requirement? What are we doing? Oh, well, if you apply to the bar and they say, have you ever had a criminal record conviction, even as a juvenile, and even if expunged, you must disclose it on this form. And that's the judiciary and the legal profession. And again, if that is the message of the elite legal profession with respect to prior criminal record, what is an employer supposed to think? Or what is a householder who's thinking of hiring a contractor supposed to think?
And that last point, we could have a whole other hour-long conversation on just how terrible that situation is within our own profession. But to your previous point, I think the biggest, the part of Ban the Box that resonates the most with me is it creates a lot of hope in people that a criminal record won't be used as a factor at all in their employment. So I think the letdown of making it further through an interview stage before being confronted with the discrimination of a criminal record can be even more impactful and discouraging for continuing to seek employment as it would be to have an upfront denial for some people. I think other people really believe that once I can show my personality and how much I'm a go-getter, then the criminal record will become less important, and they hope that they can be judged on their merits. But I think the whole conversation about Ban the Box and criminal records, you can't ignore this position of most people conducting the interview or the decision maker has a different lived experience and environment than people applying for jobs. So if you come from a neighborhood where there's relatively few arrests, it's very hard for you to think of or visualize how could you be accused of an aggravated assault. It must be what I see in TV or movies or my imagination, as opposed to the everyday conduct or behavior that it could be in an over-policed or heavily policed neighborhood. So I think just helping get past that all arrests are legitimate and all charges that are brought in fairness and with diligence for are these the appropriate charges at the right level and the right amount, is something that was lacking in our criminal justice system, and is one of the most important things that we're trying to do in the Philadelphia District Attorney's Office as way of reform, is just making sure that when we bring charges, they're charges that we know or believe very strongly that we can prove, and therefore it's fair to expose someone to all the harms that are associated with just that accusation or gravitas of Commonwealth of Pennsylvania versus an individual.
So Mike, that's again a nice transition to my next question for you, which is,
Oh, perfect.
now that you've switched from the defense side to the prosecution side, we heard a lot today about prosecutorial cultures in the keynote address earlier. That was at the federal level, and then we've heard about it in some of the other presentations. How has it been encountering your now colleagues and talking to them about this range of issues that have serious impact for defendants that are going to be prosecuted or might not be prosecuted?
I think that the most important thing to remember if you move from one side of the courtroom to the other, I don't like to say I change sides because I always want to seek justice and do what's best, but the biggest thing for me is now my advocacy has moved from the bar of the court to the conference rooms and coffee stations or whatever. So the same people that I was disagreeing with and arguing and just couldn't understand how do you come to these conclusions, I now have the opportunity to see the conversation through. Whereas before, as an advocate, I would say, okay, we disagree, we'll let a neutral third party decide. Now I have much more of an ability to try to persuade you as to why I think this is in the best public interest to better understand our prosecutorial interest. And I think related to that is this whole idea of perspective versus policy. And as great as it is and as fast as it is to just say, oh, look, here's our new policy, we're going to do this different, if we don't address the perspective that people come with in the prosecutorial or law enforcement interest, then our policy will be short-lived and very poorly enforced or embodied by our staff. So making sure that we take a holistic approach to our prosecution from the time of charging to offering pleas to going to trial, to think about the collateral consequences and not necessarily the destruction of a criminal record or should this be eligible or not. But if you're trying to do what's in the best interest of justice, you should also have this as a consideration as to, do you want this person to lose their ability to be a teacher because of this felony conviction? Or if you want this person to be held accountable, is there a way you can do that so that they can still practice teaching? Or is their conduct so egregious that you don't believe they should be able to be around children? And just helping my peers think through this decision-making, almost like immigration counsel, but for constitutional and collateral consequences for everybody else, I think is very important, and a role that every prosecutor's office should consider staffing with resources to make sure that as we seek justice, we do it from the time of arrest throughout the person's life. And the more buy-in and perspective agreement we can get on as a aspect of doing our job, we're conscious of the collateral consequences we're intentionally exposing or not exposing someone to, I hope will raise the belief in our criminal justice system by those who come into contact with it, and more importantly, by the general public. Because another important issue to this whole conversation is people very much believe our criminal justice system when it says guilty and have a lot of doubt when it says something else. So did you just hire a fancy lawyer? Was there some kind of procedural hiccup that led to you not being convicted? Because I can't understand why you would be arrested for something unless you did it. And helping the public get more belief in our convictions and uphold that integrity by looking backwards and being progressive going forward, I think is probably puts me in a better position than most to really help effectuate the cultural change we're trying to do to make a more progressive prosecutorial office focused on fairness and justice.
So just to follow up quickly, to make it a little bit more concrete, how does that perspective change look for some of the remedies we've been talking about? So, it's not known to many, but prosecutors possess a ton of discretion when it comes to expungement in almost every single state in the country. In some states, prosecutors can absolutely bar expungement without the matter even getting to a court. Pennsylvania has more of a hybrid approach with prosecutorial involvement. But take expungement, take structuring plea deals around collateral consequences. How do you penetrate maybe an existing culture in an office beyond just CLEs or educational awareness to get prosecutors to think about those things concretely?
Yeah, CLEs are helpful, but we've been doing CLEs for years. You know what I'm saying? I don't know, like people who are resistant or who have a closely held belief, I don't think a CLE alone will change. So one is just having more like-minded people in the office, so you can change just by changing people. But more importantly, I'm really trying to assuage and address the fears that are expressed to me. And that's what made me effective as a defense attorney, was to listen to see what is the reason for your objective. No, we're good. You don't have to worry about that. So what I hear in many different versions is we have a prosecutorial interest, and if this person does something, we want to know what else they have done for the reasons that Professor Jacob highlighted earlier. So what I'm trying to say is, okay, how can we improve our inter-office case management and record retention so that your prosecutorial interest is met behind the scenes and privately and not publicly? So I don't want our prosecutors going to the same database that the public is going to get their prosecutorial information. As my colleagues have said before, that database is created for a different reason and different purpose, and that purpose is not law enforcement purposes, it's to inform the public. So if we can create a more robust data management system where our prosecutors have the ability to look at previously expunged information, then they might look at granting an expungement differently because it's still there, and they have that I don't want to say hoarding, but that whatever drives someone to say, I can't throw this out because I might need it one day, maybe, just maybe. If I can give you that security without making this public, then it should be a lot of buy-in. And those are the kinds of tangible things that I'm trying to think of and be as creative as possible to really penetrate and say, okay, if this isn't enough to satisfy your concern, what else can we do from our perspective so that we're better distinguishing between law enforcement interest or prosecutorial interest and public interest and lawful use of this information? Because the best way to keep our public safe is for people to be educated, employed, and healthy and happy.
Thanks. So there are a lot of players obviously involved in criminal record history information policy. I'll direct this to you, Professor Jacobs. In your mind, which players are most crucial to criminal record history information policy reform? So are legislatures the venue that those clamoring for reform should be operating within? Is it what Mike says, frontline personnel, prosecutors, maybe defense attorneys, police agencies, other administrative agencies, the licensing agencies, the legal profession? I mean, who should be taking the lead here? Where is the route, right, that we can kind of get at to reform here?
Well, those are really good questions. And I think each of those players has a role to play. I think the state licensing function, which some of which is legislative and some of it is administrative, is very important, and we should look at all of the occupations which are closed or presumptively closed to people with criminal records, and there are hundreds of them. And a lot of those rules are truly irrational and pointless. I think so I think that would be my first area, is that the government should reform its own practices and lead by example. I think with respect to policing, we should look carefully at when we create a criminal record, because it all starts, as we've said, from arrest. Do we need to arrest, and do we need to record every arrest or even every citation? Or can some of those simply be left unrecorded to begin with? And of course, some conduct could be decriminalized and where we wouldn't be arresting for it. So the more crimes we have, the more arrests we have, the more records that we have. But I think, as my colleagues have said, once the system is triggered, it has consequences, and then everything else is a kind of catch up and pushback to try to minimize those consequences.
Janet, you've, as you alluded to before, spoken to legislators before about law reform in this area. I mean, what's been your experience there in Pennsylvania, and then which players do you think are the most important to prioritize in terms of reform?
I'm not sure I can put my finger on priorities in reform, because I do think that they all play a different role and all are important. We do a lot of legislative work, and sometimes it's been defensive. Sometimes it's been, laws that like the ones I discussed before, the Older Adult Protective Services Act, where we're trying to get the legislature not to pass laws that are, particularly restrictive or onerous or unconstitutional. Sometimes we're working to try, from an offensive and more affirmative angle, to try to get the legislature to pass laws. Sharon Dietrich and several members of the employment unit have been working for years with the legislature to pass what is being called the Clean Slate Bill, which would increase the kinds of records that are going to get automatically sealed. And the House passed Clean Slate 2 days ago. It's passed in the Senate. They have to be reconciled, but it is going to help people with nonviolent minor offenses, and with arrests are going to get automatically sealed after a certain period of time. So they're all equally important in a lot of ways. We couldn't do this work without the legislature looking at what kind of laws would protect both public safety and people and the rights of people with criminal records. We need the courts to provide a balance within the legislature. And we also need the courts and the legislature to act as a vehicle, as a remedy for actions by employers who are acting unlawfully.
So just to quickly follow that up, and all three of you can take this.
Can I just add one
sure.
more? I would just say the most important player in all these conversations are the people. And if we have enough support from people, then legislation will do what the people demand. If we have enough people, then we can outweigh special interest or whoever else is holding up actual true progressive reform. And I think that far too often we look to our peer groups as to who the key players are for reform, but if it's not driven by the desire of the people, it doesn't have nearly as good a chance of going through as actual grassroots supported changes and reforms. And the more ownership we take over the state of our society and the treatment of each other, then the faster and more long-lasting the results can be.
Okay, so then I'm going to open it up to questions from the audience here. I have a couple on my desk here. I think running through our conversation here is this question of whether, when dealing with the collateral consequences of the damage that kind of comes from criminal record history information that's public, is the answer less public information, or is it regulation of individuals who might use that information? And we have a question that's kind of along those lines, so I want to read it to you. Is there a world where we use evidence-based decision-making that does use criminal record information, but does so in a way that reflects actual risk based on past criminal history, family size, and other considerations? There's research that shows that after 3 to 5 years, there's really no additional risk of recidivism at 3 to 5 years after the original conviction date. So is that world in the future? And is this, and I think the question above that question, which is the first I asked, is this should we conceive of this problem as we should make this information less public, or should the information remain public given our legal system's priors, but we should affect the way individuals can use the information?
I would say there has to be a balance between the two. I think that some of the information that has become public to the detriment of people who are no risk or very little risk. I would like to just clarify some of that research a little bit. The research, a lot of the social science research that's emerged in the last few years is even stronger in a way than saying that the chance of recidivism goes down after 3 to 5 years. What the newer research shows is that after a certain number of years, and it's 4 to 7 years depending on who you're reading, the chance of a person committing another crime goes down almost to the same level as someone who's never committed a crime before. So I think when we try to do this balance of what sorts of information should be public, we need to keep those social science studies in mind, because we have to balance the access to this information with the public's ability really to assess risk properly. And I think we, in a lot of different things, we as a society assess risk really poorly and in sort of a knee-jerk way. And we think, okay, someone's committed a crime, we want to know about it, and we want to use that information about that person to decide whether or not that person is a safe person to hire. And I think that unless we look at the studies that show that the level, that show the levels of actual risk and take those to heart, I think that we need to think very carefully about how much information we make public.
So I would just say on this that in the age of the information revolution that we're living in now, it is practically very difficult to suppress information. Maybe it's truly impossible to suppress information. I mean, once there is a court adjudication and that is public information, it rapidly circulates through the veins of the information society. You can never make it put it away again. Also, when you're talking about people who've done time in jail or in prison for any significant period of time, they have gaps in their employment history that people could look at and ask, I mean, what is it? Where were you these last 3 years, and what did you do? We would have to face the question of should we help people to create elaborate lies about their biography in order to explain it away, or should there be some way of presenting the information and trying to put it in context? So maybe it's naive, but I think that the remedy for bad use of information is more information, getting these data out to the public, getting it more understood about the decline of risk over time, rather than people suspecting that there's all kinds of information out there that your government thinks is too hot for you to be able to handle, that they can handle it properly, but you can't handle it properly. I just don't think that will work. I don't think it will, in the end, go down very well.
Yeah, and I agree with Professor Jacobs and came to it from a slightly different perspective. When I was in criminal defense, I represented a lot of people expressing their First Amendment rights, usually described as protesters. And I would always say to myself, the best way for the government to respond is not to try to silence this speech, but to add more speech to it. And I think that it just makes more sense to me that if you want to combat bad speech, you do it with good speech and not trying to silence the bad speech, because then it leaves a gap of why are you so quiet. So the way I would advise people who had periods of incarceration is to talk very openly and honestly about what you did during that time, how you improved yourself, and add more and more information about your personal story to lessen the impact of this other information. And I think we really need to move strategically to adding more information to risk assessment tools, but not necessarily these static ones based off of other historically questionable things like your zip code and how that's impacted by socioeconomics and redlining and things like that, but more specific information to you. And if we're, as a society, moving to more and more information about ourselves being readily available, then how can we add that information to conversations so people can get a better idea of your character and less of an assumption about a risk that they're trying to measure?
If I could follow up on that just briefly, I agree that there is a problem. You know, I'm not saying that people who have been incarcerated should, you know, find a way to fill that hole, and we certainly don't encourage them to come up with a story. The vast majority of people with records, they're not put in jail, in prison. They get put on probation, and most people don't have that gap that has to be filled. I do hear you that is an issue that people are going to need to figure out how to address. I do think, however, that putting more and more information out there about everybody in their lives is not necessarily the best way to go. I'm not saying government should decide what language, what facts should be out there and not out there, but from a practical standpoint, and you've seen this, Mike, expungements and sealing of records that can be expunged and sealed help people. There's no question that laws that permit people to put these things behind them and no longer have them public, people are able to get. We see it every day. People are able to get jobs or housing that they would not have otherwise been able to get without it. And I still think that there has to be ways for people to and government to determine that there is certain kinds of information that, people's expunged records, people's sealed records, that should not be made available to the public anymore.
I'm going to open it up to another question here, which I think goes back to one of our earlier topics in the conversation. So this conversation is focused a lot on police, court records, legislative records, administrative agency records. Should we have the same concerns about inaccuracies that exist for criminal background information for the other large databases, CODIS, APHIS, those other ones that are used for DNA testing and for law enforcement purposes? I mean, do the inaccuracies that we are seeing that are pervasive here in the criminal record context exist there? And if they do, should we be prioritizing one or the other in terms of resources?
So I'll just take a shot at that. I don't think that there's any comparison. The CODIS system of putting into a database your DNA, that DNA is almost an infallible connection to a particular body. So if you have somebody's DNA on record and you check it with somebody with another sample of DNA, you can say to a near certainty that either that is the same DNA or it's not the same DNA. It's a terrific tool to exonerate people right off the bat who who are not connected, and it also helps to solve crimes. There's a lot of confusion about fingerprinting in the same way. Is it a set of 10 fingerprints can be matched almost infallibly to another set of 10 fingerprints, and we can say that this person's 10 fingerprints is the same as the others. The problem with fingerprinting comes in is when you have 10 fingerprints over here on record and you have some smudge from a crime scene and somebody comes in and says, these are the same fingerprints. Now, there is no science to that. That is a subjective interpretation, and it is subject to serious cross-examination, and it is subject to serious error. But there's often confusion in public discussions, like this information, fingerprinting is not accurate. So it is accurate, and DNA is accurate.
So one more question with respect to expungement. So there's been a flurry of expungement reform in the past 10 or 15 years across state jurisdictions. Indiana has many considered to be the most progressive expungement regime in the country now, with respect to its broadening of class of offenders who are eligible, minimal waiting periods, arrests and convictions are eligible for expungement. But I want to push a little bit deeper on this issue of expungement as a useful remedy, because there are some who would respond to you, Janet, and say, well, the information's out there. It's almost impossible to ever get it entirely eliminated. Even if you remove it from public availability, the prosecutor might still possess it, or the police department might still have records buried somewhere. And if you're an individual of particular notoriety, it might get out that way. But then there's also another core objection about expungement too, right? Which is, I think, maybe a little bit more academic or theoretical in nature, which is that expungement doesn't do what maybe Professor Jacobs or actively works against what Professor Jacobs and Mike articulated, which is that it doesn't require people to actually come to grips with the fact that individuals who have criminal records are worth actually encountering, and we can still act on the basis of the information that exists. So with the remedy of expungement, are we actually, missing the mark with respect to the real problem, or is it still actually a useful intervention that we should kind of double down on?
It's not a perfect tool. I mean, there's no question that there are cases, we see them in our practice, where even when we get a record expunged, maybe there's been an article about the crime, or maybe, it's gotten into a newspaper somehow. So, but while it's not a perfect tool, just from a practical standpoint, we see it helps so many people because, most of these, there's, as we said, 1 in 3 individuals in this country have some kind of criminal record. Not all of those crimes or cases were written up in the newspaper. In fact, a very small percent were. For the most part, expungements really do help people. Does it mean that the rest of society is not getting to know the people behind the records? I don't think so. I mean, I think there are enough people who are out there and are speaking out about this issue, and are people with criminal records are increasingly coming forward and speaking out and going to do community education of all kinds. And I think that expungement is not going to stop people in society from learning more about the issue, from learning more, from getting to know people who have criminal records, from getting to know what issues they faced in their past. But I think from a practical standpoint, it's going to help somebody get a job and get into housing.
Can I just say one thing about expungement? Is also a complex kind of an idea, and when people hear the word expungement, they often think the record has been burned and destroyed. So I think that doesn't happen. Normally, when we talk about expungement, we mean sealing. We mean that there is still the information there, either in an electronic database or in hard copy, but it is marked sealed and it is not releasable without a court order. In my book, I talk about some libel cases where a guy sues someone else for saying he in the past was convicted of a crime, and the person who has been so libeled, allegedly libeled, sues. And the question is, can the defendant show that what they said was true? Or can we just say it never happened? That never happened, and therefore you would be liable for damages for a misstatement. I think at some point, in some instances, that record has to be resuscitatable.
So just for clarification, in Pennsylvania, expungement means destroyed, physically destroyed. Fingerprints, DNA, everything gets physically destroyed. We also have sealing here for some certain kinds of things. It is true that it does mean different things in different jurisdictions, but in Pennsylvania, it does get physically destroyed.
To add some more prosecutorial flavor to this panel, under the expungement law, we have a duty to maintain those records. So it is very uncertain as to how destroyed is it and where can people still find it. But I think going back very quickly, because I know we have a few minutes left, to the benefit of an expungement, I think it, as Ms. Ginzberg suggested and stated, that it's much more of a personal impact. And for a lot of people that I met and interacted with, the expungement was the first positive interaction they had with a government agency, where you walk into court and say, "Judge, do this for me because I have a right to it and it's hindering me and whatever other reason," and a judge says you're right. And the feeling that people have where they were heard by a position of power when they're often in a class or group where that isn't the case or experienced often, I think is very hard to measure. And the way I see it play out is self-selection, where before an expungement, someone might be more apprehensive to apply for that job because they're afraid that something will come back and they'll face discrimination. After an expungement, although they don't have full confidence that it's destroyed, because we never know in this internet age, they are a lot more confident going into that interview that I won't face discrimination based off of something that happened 10 years ago, and therefore they present themselves and carry themselves a little differently than they may have before.
Professor Jacobs, here's another question directed for you. If the government sells criminal record history information, should the government have an affirmative obligation to help that individual rebrand after they've paid their debt? We see in some of the continental European countries a right to rebiography, right to reputation that's more robust than we have here. Does the fact that the government, makes money off of this to some degree mean that there should be more affirmative obligations?
No, that's an interesting thought that I hadn't encountered before. I don't know how to really. I'd like to think about that. I don't know what their affirmative obligation would be. It's an important question as to whether the government should promote transparency. And in some of our conversations, we are 100% in favor of government transparency. We don't like secret government. We don't like secret proceedings. I want to know what happened in the courtroom. And we like to have the data available. It helps us to ferret out discrimination. It helps us to ferret out corruption. It ought to build confidence in the legitimacy of our institutions. I mean, if we start saying, well, the government, for your own sake, shouldn't be giving out this information and you shouldn't know about this other information, I think it could undermine the legitimacy of our institutions. People could begin to think that they're hiding all kinds of things. So maybe they're two separate issues going on here. The government should be actively involved in helping with reintegration. This is not just for the benefit of the people with prior criminal histories, but it is for the benefit of the entire society. It's not a good thing for the society to have a class of people who are defined as outside the mainstream of society. I mean, that's very bad. The government should be working on that. But I also think, on balance, it's a good thing for the government to be transparent and to make its records of what it's doing available.
Anyone want to add to that?
I was just getting fired up because we're like the most incarcerated nation in the world, and we're going to double down by selling that information. But to what end? It's only going to shortchange us as a nation, as Professor Jacobs said, when we have a larger and larger group of people that we deny rights and opportunities to. So one thing that hasn't mentioned that impacts our criminal justice system directly in Pennsylvania, if you are convicted of a crime punishable by more than 1 year, you're ineligible for jury duty for life. Now, what bigger signal of citizenship is there other than jury duty? Maybe voting. But you can vote when you're released, but we don't trust you to judge your peers. Not in civil court, and certainly not in criminal court where you got that conviction. So closely connected to reentry or returning citizen is returning citizenship rights. And the fact that a criminal record will be a lifetime ban for criminal records, while that record can be sold repeatedly for the profit for the Commonwealth, I think is just a disservice to everything that we're trying to do from whatever perspective you're coming from in terms of seeking justice and creating a more fair society.
What if they didn't sell it? They just said the information has always been available and it continues to be available, and I'm sorry, we won't charge the user anything anymore.
I think that that would lessen some of the blow for people who already feel that our criminal justice system is designed to exploit communities that aren't as privileged or listened to. So the fact that when I used to tell people your record will be sold, shared with many different agencies, well, now this all makes sense. This was the point of me being arrested, was for the government to make money by selling the fact that I was arrested and or convicted. So I do think the sale of it specifically is a point of contention for many community members.
Well, and what I would like to add to Mike's comments about that is that a lot of, is that a lot of what we have been focusing on here is people with convictions, and less so people with arrests that didn't end in conviction, which went online in 2007 in Pennsylvania, you know, as much as convictions did. This is supposed to be a society where we believe in innocent until proven guilty. And, you know, we've talked a lot about people being able to put their past behind them. We've talked a lot about the, you know, risk assessment, but we haven't talked about the fact that people with arrests, you know, they may have some convictions, but a lot of people just have arrest records, and those are public, and those are accessible, and those are used in employment decisions and in housing decisions, and we haven't talked about the fact at all that they have not been proven guilty, and we're supposed to be a society where people are innocent until proven guilty. And I think a lot of the arguments that have been made for keeping public records public and keeping them accessible and information being open certainly should not apply to arrests that didn't end in conviction.
It cannot be the case, as I start my book, that any police officer can saddle any person with a lifelong stigma based upon nothing. That can't be right.
Are you agreeing with me or disagreeing with me?
I'm agreeing with you. That can't be right. And, you know, in fact, the next step is to talk about intelligence databases. And so that's another form of criminal record I talk about in my book, is that we have increasingly created gang databases organized crime databases, terrorist watch list databases, based, again, on police suspicions about people, but where there's not even been an arrest, where there's no probable cause, where there's no charge, right? So what are we going to do about all those data? And there, I think that should not be transparent, and I think the same for the arrest data, and we should have a very different conversation about arrests. Arrest is not, I think, a public event in the way that a court conviction is a public event. Do I agree with you?
So I think we should all thank our panelists for giving us a lot of interesting ideas to think about.
Excellent. Very interesting.